many times in court, the claimant's giving evidence, and what he says is he's asked the question of when you first noticed your hearing loss, and he says, well, I didn't, to be honest. It was my wife who noticed it before I did, and she kept accusing me of ignoring her, and that brings a smile to the judge's face. And so that was the first slide I had. I found this, and I thought it really summed up what we often see in court, actually, where the claimant himself or herself are unaware of the hearing, but others around them. Now, talking about the basics, effectively, what you have is a chart where hearing loss is measured, and across the bottom you've got the frequency, the pitch of the sound. The lower the pitch of the sound on the left, going across to the right, the high pitch sounds on the right, and then each circle and each cross on there represents different frequencies of sounds. This is effectively the audiogram, and it shows the measure of loudness increasing. The circles and crosses are the quietest sounds in that frequency that the claimant can hear. So if the claimant hasn't got perfect hearing, then effectively those crosses and circles will be further down. So it'll take a higher level of sound to get a response from him on the audiogram, and I'll go into that in a bit more detail in the next slide. So usually normal hearing is between 0 and 20 decibels, normal range. That's somebody with perfect hearing. And then you have the lower parts of that slide that you can see, where if it gets into the around the 30 decibel range, and the ranges are measured in the decibels, is a mild range, then the moderate, severe, and moderate to severe, and severe and profound. Anything that's 40 to 60 is classed as moderate, and usually at this stage people are fitted with hearing aids to help them hear better. But when you get towards the bottom end of that, the severe and profound hearing is where the hearing loss is touching 90, 100 decibels. In that area, usually hearing aids don't always provide a solution, because it's that loud, it distorts the sound of the claimant still having difficulty hearing. So that's a normal kind of hearing chart. Now, as we get older, presbycusis basically is age-related hearing loss, and as we get older we all lose hearing. And it's amazing how the system is, because we all have a reservoir of hearing, and you can lose a certain bit and you still won't know that you've lost it, because there's a bit of extra that's there. But at some point, as we all age, you start to lose hearing. And what this chart does, and this slide shows, is a gradual loss of hearing as people get older, and it's towards the later frequencies of about 2 to 8 kilohertz that people start to lose hearing on. Now, in a few slides, I'm going to put that into context, and I'm going to kind of highlight what type of sounds and what type of noises one gets at these frequencies. But for now, that's a classic sort of chart. If you took an elderly person and you did a chart, and he didn't have any other related hearing loss from anywhere else, that is the classic sort of chart that you would see. So the one, if I go back one, that's perhaps somebody in the mid-20s, normal hearing, no hearing difficulties, and this one's somebody who's further aged and perhaps in the late 50s, 60s, 70s. That's the sort of effect that you get. Now, age-related hearing loss can be calculated, and there are tables to allow that, and often you'll have seen that medical experts will say, well, considering the age, he falls into this bracket, and therefore this is what we'd expect of his hearing loss, and he's closer to this bracket than that bracket. And they often disagree on the relevant bracket that he should be in, but usually it's the dependent on age and perhaps a couple of other factors, but nothing more. So it's guesswork. Now, this classic table is or graph is very important, because in a normal person, what you get is fairly normal hearing loss, and then suddenly at a frequency of around after 2 and between 2 and 3 and 6, usually they say, the chart just dips down and then dips back up. And the reason that that is because often noise exposure damages the frequencies around this. So it damages the cochlea, the hearing organ, and what it does is it seems to damage loud noises or prolonged exposure to noise at a dangerous level affects the 4 kilohertz frequency more. The Coles guideline suggests it's 3 to 6. 4 is the classic. Charts can be distorted, and defendants often say, well, it's got to be 4, it can't be 6, and we will often argue that that's wrong because it's not in accordance with the scientific research. And so what you have there is a classic audiogram showing some sort of noise-induced hearing loss. Now, noise-induced hearing loss, what we've got to remember, is a process of elimination. You cannot go in and say, this is the test and it reveals noise-induced hearing loss. What you've got to remember is that noise-induced hearing loss is actually diagnosed by elimination. So what you say is, this claimant's normal hearing loss, considering age and considering all of the factors, should be this, yet he's got extra hearing loss. So what is that extra hearing loss related to, or what could it be related to? Has he been firing shotguns? Has he been in the army? Has he been riding a loud motorbike? Was he a DJ? And then you eliminate all of that. That's why in classic medical reports, what you find is that the medical expert will negate all these possibilities. He'll say, well, I've checked with the claimant. He didn't serve in the army. He didn't fire shotguns. He didn't go discoing every night for 10 years. He didn't do this. He didn't do that. And one thing he did do was work in a noisy environment. So subject to engineering evidence, the only probable cause that I can see for this downward notch is actually his work. And that's medical causation kind of made out. So those are the classic charts. Now, when you look at, I'll deal with asymmetry a bit later on. In normal terms, what you'll get is a similar sort of audiogram in both ears, and the graph will be fairly similar. There will be a little bit of difference, but anything within 10 decibels is considered to be normal. It's only when there is a great differences between the two ears that things start to get more complicated. Now, back in the early days, and it's very interesting and a historical thing that before the Coles guidelines in 2000, there is some interesting case law in this area because different people came to the courts with different ways of trying to prove hearing loss. And there were all sorts of different theories that they developed because there was no set way of doing it. And so if you look at some of the older case law and you read some of the ways that it was done, they were quite inventive and quite good. And the medical experts were teaming up with the legal teams and trying to prove that this hearing loss was noise related. In 2000, Coles, Lutman and Buffing put their heads together and they produced some guidelines. And what the guidelines say is these are guidelines, not rigid rules. But the way that this area has developed and the way that it's suddenly mushroomed and a lot of claims have come on, especially with the Wolf reforms, because normal run-of-the-mill kind of personal injury work hasn't been as lucrative, and so people have moved into this area. And unfortunately, they have become rigid guidelines. So although a lot of the time that works quite well, sometimes what happens is that there are genuine cases where there is noise-induced hearing loss, but because it doesn't fit into the strict regime of the Coles guidelines, judges will not entertain it. I did an appeal a few years ago in Swansea, I think it was, where I argued till I was blue in the face in front of a circuit judge. And I said, look, this person has got hearing loss and it can be proved in other ways. And he accepted what I was saying, but still rejected the claim. He said, I can see where you're coming from, but he was just uncomfortable going outside the CLB guidelines. So really, they've almost become a set of rigid rules, but that's where we are. The problem with them is that there is a whole barrage of these cases flooding the courts, and so the courts needed certainty. So the Court of Appeal composed of very clever people. What they thought is, if we start to open this can of worms again, we'll get back into a scenario where we're pre-2000 and it was a mess, because how are different judges up and down the country going to decide these if there are all sorts of different theories? So they've kind of gradually closed that door. Properly speaking, you can prove the claim in any way, but what they've done is they've decided to close that door, so we're stuck with the Coles guidelines, but they have been revised, and I will come to the LCB guidelines a bit further on. Now, To prove a case under the Coles guidelines, if I move my slide on, you've got the 3 R's. So the 3 R's, there should be evidence of high frequency hearing loss, at least 10 decibels or more, loss at 3, 4, and 6 than at 1 and 2. So if I just go back to the chart there, you can see there that at the 250, 500 kilohertz, 1K, 2K, and then suddenly there's a drop. And on that particular audiogram, it shows a drop of 20 decibels. So that would satisfy it, because suddenly you've got this drop that's unexplained. So that's that. Then you've got your R2A. Now, having this audiogram and it's showing a drop on its own doesn't prove anything. There could be a whole host of reasons why that has happened. But when you combine it with engineering evidence which shows that the claimant worked in a place where the noise levels were such that it could have damaged his hearing, and that his overall exposure to that noise, and this was the noise emission level with an I, has been as 100 decibels over his lifetime, or between 90 and 99, and I'll come back to the difference between the two. Then you've satisfied the second part. So the first part is that drop you see at the 2 kilohertz from there down to the 4 at 20, and then the second, that the engineer comes back and says yes, overall lifetime exposure is that. And I've given some examples in my handout, which you get circulated to you on your emails. But 80 decibels over 50 years will get you 100. 85 decibels over 32 years of exposure will get you 100 dBA NIL, and 90 decibels over 10 years will give you the 100 decibel NIL. So essentially, it really depends on the level of exposure and the period of time. But that's the second requirement. Now, there is a R2B. If the lifetime exposure is not as high as 100 decibels per NIL, you can still make a diagnosis if this drop, and if I just go back there, the drop from the 2 kilohertz to the 4 is at least 20 decibels. What that does is it really shows that there is, on the balance of probabilities, there are more chances of this probably being related to noise-induced hearing loss. So that's there. So it's a little bit of a help where you've got a audiogram which shows a bigger drop and a bigger hearing loss, and you've got some exposure which may not be quite as high as the noise emission levels that in normal cases you have. You can still, on the balance of probability, say this is noise related. And so when you've got this, say you've got 80 decibels, then on the original example, 80 decibels of exposure, you needed 50 years of exposure. Whereas if it's 95, for example, it's a logarithmic scale, but 80 decibels you could do in 32 years. So 90 decibels, and this is the interesting one, can be reached in 3 years. So if you've got an audiogram which has a bigger notch and that drop of high frequency hearing loss, and then even 3 years of exposure at 90 could achieve the relevant NIL, and on the balance of probabilities produce noise-induced hearing loss. The last requirement, we'll go back to the other slide, is that the audiogram should show a notch or a bulge shape with a bilateral drop of 10 decibels or greater. And these bulges are identified by different patterns. I'm just going to move on to the next slide. In summary, where there is a 10 decibel visible drop on the audiogram, R1 is satisfied. Where the noise emission levels are 100, R2A is satisfied. And where there's a notch or bulge of at least 10 decibels, R3A is satisfied, and there's diagnosis made. And then the alternative situation where you've got R2B, and I've set that out there. That is your classic notch. On that particular audiogram, it's kind of perhaps emphasized a little bit more for us to fully grasp it. And typical notch. Why? Because the frequency of 4 kilohertz is worse affected, 8 isn't. So usually the claimant's hearing will improve. A lot of causation arguments you will have seen and you will get where it doesn't improve, and the defendant say, well, there must be some other cause here, because if it was noise-induced hearing loss, one would have expected the hearing at the higher frequencies. It hasn't, so there must be something else, some sort of ototoxic medication, because certain types of medication can cause hearing damage, etc. So they'll then run those arguments. But those are clutching at straws if one knows where the defendants are coming from, because they're in a difficult situation. Reason being, we know from experience that we often get this, and I'm hoping that the slide in relation to the bulges there. Now, what happens is, for a whole host of reasons, although the hearing should improve, it doesn't. So what the experts are required to do is do a bulge analysis to say, well, look, it should have gotten better at the higher frequencies, but there may be some unrelated cause which is making the 8 kilohertz or the 7 kilohertz frequency figure different. But that doesn't rule out in itself the fact that there is noise-induced hearing loss at 4 kilohertz. So you can't use that as a defense. And that's where the causation arguments come in between the experts. And a lot of the time it's a strong argument to say, well, just because there isn't the skew back up doesn't mean that there is no noise-induced hearing loss. So that's like notches and bulges, and your expert will carry out a bulge analysis and say, yes, you know, when I've carried out my bulge analysis, if this was going back, it'd be a classic type of audiogram, so that you wouldn't have in that one the 8. You would have the 8 kilohertz at the top, but unfortunately what you've done is, because of something else affecting the 8 kilohertz, it's not shot back up. Symmetrical hearing loss. That audiogram shows the X is one ear, the circle is the other, left and right usually, and that shows symmetrical hearing loss. Both ears are fairly similar. There's small differences between them. There are bound to be, and 10 decibels is ignored, up to 10 decibels is ignored. So that's what a symmetrical hearing loss, that's what a symmetrical audiogram looks like. Now, often we have problems with these, asymmetrical hearing loss. And what one finds is that you've got one ear that's worse than the other. So the defendants come back and they often say, well, look, this cannot be noise-induced hearing loss related, because common sense dictates that if you're exposed to noise, both ears would be exposed. And if both ears are exposed, then how can it be related to, they both would have been damaged. And so because only one is damaged, therefore, this cannot be noise-induced hearing loss. That isn't right. And basically what you have to do is you have to carry out the analysis in accordance with Coles for each ear, and then Coles and Lutman and Buffin have themselves given some guidance on how exactly to calculate. But before we move on to that, let me give you some interesting tips on asymmetry, because often defendants will come back and make a song and a dance about asymmetry. Now, asymmetry actually has been dealt with by Coles in Note 11, for those of you who are familiar with it, and it occurs quite a lot. It occurs in the general public, and what the articles, because this is an academic area, so there are a lot of articles here, what they suggest, a lot of research suggests, a lot of studies suggest, is that especially in those workers exposed to noise, there is a higher frequency of asymmetry. So it happens naturally. Nobody knows why. There are a whole host of theories that people put forward. For example, that the claimant, that the machine that was noisiest may have been on one side of the claimant. Maybe the hearing protection he was wearing protected one ear more than the other. There are a whole host of reasons that different academics put forward. But for the defendants, they've created almost a very interesting defense from nothing, because they often turn around and point blank say, well, there's asymmetry here, so this can't be noise-induced hearing loss. And the number of times I've heard that when they request their own medical evidence at a CMC is amazing, because the first thing that I say is, well, hang on a minute, the basis of your application for medical evidence is asymmetry, and yet asymmetry can happen without any causation difficulty. It can happen when in the general public, and it can happen when a worker is exposed to noise, and that in itself is recognised by Coles Note 11 and by articles. How can you say that asymmetry justifies further medical evidence? And so that then puts them on the back foot. But asymmetry is fairly frequent. Yes, you will get situations where you will have to deal with asymmetry, but if we look at different articles, what they say is that asymmetry in one ear still does not mean that there is it can't be noise-induced hearing loss. In fact, what the article suggests and what Cole suggests is that on balance of probabilities, there still can be hearing loss, even though there's asymmetry. So it's one small factor that the expert needs to consider, but it's nothing more than that. And it's not this general smoking gun that the defendants try to argue it is. So like I said, 1% of the general public have asymmetry, asymmetric hearing loss. Different individuals suffer hearing loss in different ways. Two people side by side exposed to noise may damage their hearing, exposed to the same noise may damage their hearing in different ways, at different frequencies and at different depth. Now, it's exactly the same with the two ears. Two ears on each side will react differently, and that's why you have asymmetry, which is so common in the general public, and it can occur in noise situations as well. So it's not a fact that if it's asymmetry, it cannot be noise-induced hearing loss. The next area that I wanted to touch upon was disability caused by losses at 4 and 6 kilohertz. Now, what defendants sometimes argue is that because the claimant's losses are at 6 kilohertz, it can't be noise-induced hearing loss. Well, that's not right, because when one looks at the Coles guidelines, they say 3 to 6. Yes, the classic notch is formed at 4, but that doesn't mean that 6 kilohertz loss is not compensatable. And this is a classic chart which helps us with that, because if you look at this audiogram, what we've got here is the sounds that people hear at these frequencies. Now, if we look at these frequencies, what we find is that towards the top end, you've got the th, sh, s, th sounds. And so when people start to suffer at that frequency more, so if it's around the 6 kilohertz mark, they actually struggle to hear the th sounds, the s, and they feel like people are mumbling. So it is causing them difficulty. So where the defendants try and argue that 6 kilohertz doesn't, there are plenty of articles. I think there's a very good one by Professor Moore, who specifically deals with this and says that any suggestion that losses at 5 or 6 kilohertz past the 4 kilohertz mark don't cause disability is absolute rubbish, because he says, well, if you're not hearing the first sounds, the s sounds and the th sounds, you can't follow a fair percentage of a conversation. And if you're missing 15 to 20% of a normal conversation, if in every sentence there are these words used quite often as they are, then you are at a disability. And anybody who suggests otherwise, Professor Moore says, needs to look at what they're talking about, because it just doesn't make sense. And so these are very important. So losses at 6 kilohertz, defendants often come back and say, well, that's a 6 kilohertz notch. That doesn't apply in noise-induced hearing loss cases. Yes, it does. All we need to establish is that the damage was caused by the noise. Now, where you've got an engineer's report which suggests that, where you've got a medical expert who says there's no other cause for this hearing loss, and yes, it's not at the classic 4 kilohertz, it's slightly higher, it is still related back to noise. And if it is, what's the disability? Well, Professor Moore says there is significant disability, because if you look at where people recognize at what frequency certain sounds come at, there are at least 3 or 4 crucial sounds that are used in everyday language which are at that frequency. If the claimant can't hear those, he's going to struggle. In relation to asymmetry, the handout that Kirsty will send out to you has a long section on it. What I haven't done is gone into it in great detail, because it was basically different scenarios of what you can have, where you have 15 decibels, 20 decibels, and how you deal with those. So I've put it in a handout, and hopefully at some point Kirsty will circulate that. And that's why I moved on to deal with these disability. Moving on to the next chart. This is exactly what I was just saying, that basically where you've got this chart and it shows the fir, sir and thir sounds. Now if somebody's got the loss at 6 kilohertz, he can't hear those. And if it's that sort of audiogram, this person may not be hearing the per, her, ger sounds, the ker, the f, the ses, the th. And so he's missing a substantial part of conversations. And this is what puts the claimant at disability. And sometimes it surprises me when you look at the academic articles and you look at these charts like this, you think, why do the defendants argue this? But again, it comes back to the fact that these are difficult cases, so they have to find something to argue about, so they find anything. Let me give you another example. Where you say you have defendants who come back and say, your expert says that at 1, 2, and 3 kilohertz, the loss is only 2.5 decibels. But it's unfair to use 1, 2, and 3 kilohertz in this case, because if one looks at the audiogram and looks at the claimant's position, it is fairer to use 1, 2, and 4 for the average. And if you use 1, 2, and 4, you get 10 decibels. That's a good argument, but it has to be tailored to the case. You can't use it generally. And in the early days, we had cases where the experts were only using this rarely, and we often got home on it because they explained why they were using 1, 2, and 4 rather than 1, 2, and 3, which was the conventional approach. What I've seen in the last perhaps 12 to 18 months more is that people tend to just throw this in. And then when the expert is asked to explain in detail why he's saying it should be 1, 2, and 4 rather than 1, 2, and 3, they're struggling. They're struggling because what they've done is, because they calculated that 1, 2, and 4 is a better reading, they threw it in, but didn't have the justification for it. And then you fall back onto the position of 1, 2, and 3. It's 2.5 decibels. Is it de minimis? And I've got some notes on that a bit later on. I will deal with the de minimis argument because a lot of that now has come out. LCB have brought a lot of de minimis arguments about, and I've got some case law I've put at the back of the handout as well, which will come out to you. So this is the classic sort of chart, and this is a very good one actually, because if we look at different sounds, you will see the types of sounds that are at different frequencies and different levels. And so around the 4 to 8 kilohertz mark, around that area, you'll see the types of sounds that you will miss. So you've got your birds tweeting, you've got your F, S, and third sounds that I mentioned. You've got the Hoover, which you won't miss, the phones ringing, door knocking, things like that, that often claimants mention are all in that sort of that side of the chart, which can all be badly affected. Now, if you look at from 2 kilohertz down on that far side of the chart, there's quite a lot there. So a claimant who has significant hearing loss does miss out on quite a lot. And so needs hearing aids, and very few know that. And often, by the time they've come to us, they haven't even. A few have gone to the NHS and got hearing aids, but a lot of them haven't put their mind to it. They've just carried on coping the best they can, and that's where we can help them. LCB, the wonderful world of LCB. Well, LCB, the same experts, they put their heads together in 2016 and they came up with the new LCB guidelines. The initial guidelines, the Coles guidelines, were to diagnose noise-induced hearing loss, but they weren't really good on quantification. They were general guidelines. So the three experts put their heads together and they came up with the LCB guidelines. In the first few years when they came out, there was a lot of problem with them because they weren't generally accepted. They were controversial, and some of the readings produced negative readings. Some of the calculations, produced negative readings. Some things didn't make sense. It didn't deal with all situations, so it left a lot of questions. What the defendants did is latched onto this and always went for an LCB calculation from their expert. If it helped them, fine, let's keep it. If it didn't help them, let's not talk about it. So we got a lot of cases where LCB was mentioned as a convenience. If it helped them, fine, it was in there. The difficulty with LCB was it brought a lot of uncertainty, especially in terms of the de minimis arguments. Generally, over the last few years, the courts have started to accept them more because experts are now using them a lot more. What you'll have is the CLB calculation followed by the LCB calculation, and it's really to argue in court. In my mind, I still don't agree with that approach, but the courts have been kind of forced into it by doing their own analysis. And the reason I don't agree with it is because what you have is when an academic in a particular area, whether it's astronomy or physics or chemistry, the experts will come up, or the academics will come up with a theory, and they'll say, this is what we think, this is how this should be done, these are the guidelines, and then they'll get peer reviewed, so that the people will go through them and say, well, we don't think that's right, we don't think that's right, and this needs to be amended. And then over the coming years, they'll get peer review, they'll be criticised, they'll be commended, everything else, and then you'll get a revised set of guidelines, which probably could be classed as guidelines. With the Coles guidelines, we have 20 years of experience in the courts, in the academic field, and everybody thinks that they're quite good and that they do the job. Apart from, say, the little thing that I mentioned at the beginning, where there are certain situations they can't deal with, and certain claimants will be left uncompensated because they don't fit into that little framework. But apart from that, they were quite good. Problem with LCB is it's not gone over through the peer review scrutiny that it should have done, but it came into the court forum because when it came out in 2016, we had an influx of noise-induced hearing loss claims. So defendants were trying to find something, and along came LCB, and it gave them a little bit of help. So at the moment, it's important now that we get our expert, if the defendants are using LCB or they're suggesting it, it's important that our expert uses LCB. There were a few experts back in 2018 who didn't use the LCB as claimant experts. Now, as standard, I think most of them, if they're asked to do it in questions, etc., they will produce the LCB, calculations for you. And those can form part of the claim. And what I usually say is there's no need for them unless the defendants raise them. Some experts do tend to go that extra mile and put them in. In my mind, it could open up a can of worms. Why do something you don't need at the moment? If the questions arise at a later stage, if the defendants get their own medical evidence and their expert says, well, under the LCB calculations, it comes to X. Well, surely there's going to be a joint report between the experts, and our experts can deal with it in replies to questions and or in the joint report. So at that stage, it can be brought up if necessary. But if it's in there from the beginning, it just gives an extra line of attack to the defendants to say, well, there's a difference. Look, CLB calculates this, but LCB is quite low, etc. So it's always good. I mean, like what I always do say is that when, like the defendants do, use it as convenience. Use it as convenience. If it does come back with good calculations for the particular claimant, get the expert to throw it in. It's always good for the experts. They should know this. It should be like the back of their hands. So they should be looking at LCB and thinking, well, looks good, this. Let's put it in, and always get it in. That's a good way forward. The next area that I wanted to look at was, and again, I've got a small section on LCB and what they say and how they're used for quantification and how the assessments are, and those are all in the handout as well. I didn't want to dwell on any particular topic too much. I want to kind of give an overview and move on to the latter part of this, which is got about 20 minutes left, and I'm looking at part 18's witness statements and CMCs. As far as CMCs are concerned, these are often now 99% of the time allocated to the fast track. Even if the damages were greater than, say, 25, probably judges would still exercise their discretion now. That was unheard of when I first started to do noise-induced hearing loss claims 5-6 years ago. Everything was multi-track. Some of you will remember at that stage. These days, the classic case management conference arguments are in relation to further audiogram, defendants' own medical evidence, and Part 18 requests. A lot of people, when it comes to further audiogram, they think, well, how can we stop the defendant? We tend to challenge a lot of these requests for further audiogram because they're simply fishing. So what we say is that further audiogram is akin to expert evidence. Part 35 says that needs to be restricted to that which is reasonably necessary. It's not necessary because the NHS, Specsavers, everybody else does one audiogram. That's enough. It's reliable. So long as the audiogram is reliable and repeatable, and that usually it says it on it, and the expert, the claims medical expert, will say, have a specific section. It'll say the audiogram was reliable, the audiogram was repeatable, all the conditions were met, the British Standard of Audiology guidelines were met, and therefore there's nothing wrong with this audiogram. And so when the defendants come along and say, we want a further audiogram, the first question that I ask is this: why? Because they have to satisfy the judge. And sometimes judges think it's a simple step. It only costs 100 quid, 150 pounds. It can be done in a few weeks. Why not? Well, with respect, that isn't the test. The test isn't if it's a cheap step, let's do it. The question is, does the CPR allow it? And if the CPR says expert evidence needs to be restricted to that which is reasonably necessary, this is an audiologist who's carrying out a test. And so they need to show that there's something wrong with the existing audiogram. And often they can't. There will be cases where there are some question marks, but sometimes the best they can do is say, oh, we don't know what condition the audiogram was carried out on. It was carried out in a hotel. It wasn't ideal conditions, etc., etc. Well, we challenge that, because what we say is this. First of all, you can ask the experts what conditions it was carried out in. We sent you the medical report months and months ago. You haven't bothered to ask any questions in relation to the audiogram, the conditions, or anything else. And B, even if it was carried out in, say, not a soundproof booth, it doesn't really matter, because the expert will have measured the background noise and then done the relevant calculations so that he deducted any background noise from the readings so that they're accurate readings. And that's why he said they're reliable and repeatable. So the fact that it wasn't a soundproof booth doesn't make the audiogram unreliable. And so we challenge it in that way. Sometimes what the reason that defendants may get an audiogram is because there is uncertainty in relation to readings, or because the audiologist hasn't filled the audiogram in correctly. So he's left boxes unticked, etc., hasn't confirmed certain readings, there are blanks on the page. And in those sorts of circumstances, then it puts us on a back foot. So the defendants go off and get their audiogram. Some of you might be thinking why we're against the defendant's audiogram. The reason is simple psychology. They're trying to find any way of challenging this. So when the audiograms come back, an audiogram is a subjective test. So basically, claimant sits there with a little buzzer, a little button, and whenever he hears a sound, he presses it. And so two audiograms are never the same, and they can't be, because it's the nature of the test. So when he goes along to the defendant's expert, and he's sat there, and if there's a difference, suddenly the defendants will then start to argue that there's a big difference between these, and therefore the claim's credibility is in question, or that there's some other underlying cause between the first audiogram, which was 3 years ago at the time of the medical report, and now we're at the court in court proceedings, or some other causes. The other thing that we found in where we've had defendants have their own audiogram is this: their audiologist is acting as an investigator. So what the audiologist does is, oh, Mr. X, when did you notice your hearing loss? And Mr. X said, well, I think I complained to my wife in 2004. And he makes a little report out, and together with his audiogram, you get a little report saying, claimant said, I did. And so you've got a witness for the defendants almost, because the claimants, and what has happened is the claimant's gone along perfectly innocently, not thought about anything, not thought he's going to be asked cross-examining questions by the audiologist, but suddenly you've got an audiology report with all sorts of comments at the back, which are brilliant for Mr. Parker and Mr. Hughes, because they can make a meal of it. So this is why we thought, okay, let's try and restrict these audiograms to cases where they are needed. There are some cases where the experts will say we need a second audiogram. We cannot determine this, and they're better than the SERA test. So let's go for a second audiogram. Yes, but a lot of the time, that's why we fight to avoid these second audiograms. The other area in CMCs that is often argued about is medical evidence. Defendants wave about the case of Dalgleish and say this means that no matter what, we are entitled to our medical evidence, and therefore you should concede. No, Dalgleish says in appropriate circumstances there is nothing in theory stopping a court ordering that the defendants should have an equality of arms and they should have their own medical evidence, but certain conditions need to be satisfied. They cannot simply come along without identifying specific detailed areas of concern in the claimant's medical report, and having never asked questions in relation to those areas of concern, and then suddenly say, we want our medical evidence. That's not right, and it flies in the face of the CPR and the overriding objective. A lot of these cases are now limited to £5,000 that fast track, and they don't justify thousands of pounds for the experts unless there is a reason. And so defendants shouldn't be allowed to look at the claimant's case and say, well, that's a pretty good medical report and it's a pretty reliable audiogram, and it does look like the classic notch formation is there and everything else. But I tell you what, because we haven't got a leg to stand on, let's go to another expert, preferably somebody who likes working for defendants, and see if we can find anything in this case that we can make a case of. That's not what the CPR says. The CPR says that Part 35 is clear that expert evidence should be restricted to that which is reasonably necessary and required. So what we always argue is, look, Judge, you need to be satisfied. It's not a case of, defendants want to go fishing and you say, fine, well, they've got no, they've got no alternative. They can't find anything to really challenge this case. So let's give them a license to go fishing. That's not good enough. You have to be satisfied that on the balance of probability, the experts in this case hasn't dealt with issues that needed to be dealt with, and the defendants are allowed, having identified those issues and having asked questions for clarification, but the expert stood by his ground on each one of those, they should be allowed to go and get another opinion on that particular point, which may be an academic point. And seldom do defendants do that. Sometimes they do. They have a statement, and sometimes these statements just waffle on the standard cut and paste jobs, and they have these standard, and they don't relate back to the case. So we always argue, look, you've got to relate it back to the specifics of this case and justify your request for medical evidence in this case. Waving Dalgleish in front of the judge just isn't good enough. And so on cases standard, we say, look, ask questions. And the key that I find recently, because there's always, it's a shifting process for those of you who've been doing them over the last 5 to 10 years. What was working in front of judges 3 years ago isn't working now. But the key at the moment is that instead of saying the defendants shouldn't be getting their medical evidence at all because of X, Y, and Z, I simply say, Judge, this is a fast track case. It's limited to £5,000. We want to move to a trial. The evidence at the moment makes total sense. The defendants have put us in a position where they've failed to ask questions, and they should go back and ask questions. We're not saying they shouldn't have their medical evidence, but ask questions, identify the issues so that the court can make a decision under Part 35 of whether it's necessary to get further medical expert evidence. And usually that works. And the judge thinks, yeah, because we're not restricting it. And some defendants, funnily enough, fall for this one as well, that you can give them permission to make an application once they've got the replies to the Part 18s. And some learned judges say, yeah, fine. So they put it in the order. The defendant has permission to make an application for further medical evidence. And the defendant's representatives walk away thinking, well, I've got permission to make an application. Well, they didn't need permission to make an application. You don't need permission to make any application under the CPR. So when they make an application, it's like a fresh application, but it gives them that peace of mind, and it gets us away from the CMC without them getting the medical evidence. And hopefully once they've asked questions, we're a bit down the line and they think, well, let's not go for it because it's going to be an application, it's going to be risk on cost, everything else. So if you manage to get away from the CMC without defendant's medical evidence, there are only a few cases from your experience, you will know, where the defendants do actually stick their neck out, make an application for specific, for their own medical evidence. So that's kind of CMCs in a nutshell. The slide that you've been looking at for the last few minutes is Part 18s. This is one where I have had nightmare cases. Time's moving on. I had a case a few years ago where there were 3 or 4 defendants in this case, and during the life of the case, each defendant had asked the claimant Part 18 questions at different times, and the instructions solicitors had sent them on to the claimant. The claimant had sat down and written the answers. They went back to the solicitor, sent them on to the defendants. And then down the line, proceedings are issued, and I got it at some stage. And I had a look at it, and I said, throw it in the bin, because each of the Part 18s totally contradicted each other and contradicted the witness statement. And it wasn't the poor claimant's fault, because if you start asking somebody over a period of 3 years, every 6 months, about similar sort of things and work conditions and noise exposure and limitation, the memory plays tricks as well. The claimant just filled them in as best he could. Nobody really checked them, and they went off. So there's a real reason why we hate Part 18s, and there is a real reason why the defendants use them. The reason the defendants use them is this. You will have seldom seen Part 18s where the Part 18s are consistent with the witness statement. They never are, because Part 18s are just questions fired off. Claimant doesn't get the opportunity to think about them thoroughly and properly. He's not guided on them. He sends them out and thinks that's it. Flip the side, when the claimant sits down to do the witness statement, you take him through methodically every step of the process. There's a very detailed witness statement. Claimants have the opportunity to think about things. He's clarified things. Everything is in sequence, in chronological order. Claimant's happy, employment history, everything else there. So in that context, now that the claimant understands the case and understands everything, lay claimant, and often elderly, now he's in a better position to deal with any questions not right at the beginning of the claim, where he can be caught off guard, who's not thought things through. So this is why the defendants use them. There's no other reason. The defendants use it as a tactical ploy so that they can exploit this and then come back and see whether there's any contradictions. They often quote the fact that, oh, we need more information, the particulars of claim are not detailed enough. That's actually rubbish, because they say that, oh, the particular claim is defective. Well, part 16.4 says the particulars of claim should have a concise summary of the facts, and that's what they do. What they want is they want the evidence and the meat on the bones, and that, under the CPR, it doesn't come at this stage. What the defendants often believe is you have issue proceedings, file a defence, and then fire in the Part 18s, and then we'll have disclosure, inspection, witness statements, and then list for trial. That's rubbish. What the CPR says, really, in real terms, is have a defence, then have a CMC where you'll have directions for disclosure, inspection, witness statements, and then if anything remains unclear, then ask Part 18s if it's crucial information. But then, pausing there, if it's crucial information, and as a claimant, I've missed it out, I've missed out relevant information, my claim's going to fail anyway, so I wouldn't do that. So what they do is they try to put the cart before the horse, and they try to ask the Part 18s early. Now, the CPR doesn't allow that. CPR allows to clarify any matter in disputing proceedings, but it specifically says, and on that slide you can see PD 18.1.2, a request should be concise and strictly confined to matters which are reasonably necessary and proportionate to enable the first party to prepare his own case or to understand the case he has to meet. Now, that is very, very clear. Concise and strictly confined to that which is necessary, not the 30-odd questions that they fire with 5 sub-questions each on every single area that the claimants possibly could be challenged on, from limitation to exposure to causation. That's not what Part 18 is designed for. And I had a judge who said, well, do you think any Part 18s can be requested at this stage? And I said, yes, Judge, there are. If the defendant said the claimant worked in a factory has 5 floors with 3 departments on each, to comply with our duty of disclosure, please let us know which department he worked in, because we can't disclose to you the records for the entire building. Perfectly sensible question at an early stage. Why? Because it helps them prepare their case, because they know what disclosure they have to make. If the Part 18 request comes back and says, who were the claimant's work colleagues, who was his supervisor, who was his manager, a perfectly sensible question, because they need to get witness statements. So it's going to help them in their obligation to get witness statements. The part that really annoys me or disappoints me is these are general questions. How long did he spend on this machine? Which machine did he work on? Whereabouts was he in relation to this? This is all information that is usually contained in the witness statement. And the way the CPR works is that the meat comes in the witness statement. Oh, we're blind because the defendant's dissolved. Well, these are experienced NIL-HL solicitors. These people know what they're doing. And what possible use are they going to make of this information? Well, they come back with the argument, oh, well, the engineer's going to need this. Well, hang on a minute. If the engineer's going to need this, surely the engineer is going to only be instructed once the witness statements are in, because the engineer can't produce an engineering report based on Part 18s. The engineer is going to base his report on the one most important document, apart from any noise surveys which the defendants have or any other disclosure. The most important document is the claimant's statement. So by giving you these Part 18s has nothing to do with the engineer. And this is often an argument. They say, oh, we need it for the engineer. You don't. And it's just common sense. So a lot of the time, the defendants are just using this as a tactic to try and catch the claimant out. The Court of Appeal has said time and time again, I won't go into it in great detail, I've only got a few minutes left, so I wanted to move on to my last section. But the Court has said that, you know, interrogatories are gone. The requests need to be necessary, and it's a very stringent test. And again, in my notes, because I do a lot of these Part 18s and applications and all that, I've put a very detailed section in, which you'll find very useful, especially for your statement. You can cut and paste it in, it'd be good. And it's got all the case law in there as well. That will help. But we very, even if there are questions that are relevant, what I always argue is that hiding 2 or 3 relevant questions in 30 that should never have been asked is not good enough. They need to revise their request. But if you do spot them, sometimes it's good to protect yourself on costs if it's a specific application. If it's a CMC, then it usually costs in the case, so you can argue without any cost consequences. But if it's a specific application, what tactically might be clever is this. Defendants might have 2 or 3 or 4 valid questions and that they need to deal with disclosure and witness statements, etc., or they could do it in an early stage. And it might be good to say, well, questions 5, 8, and 10 we think are relevant. Here's the answer. Make an application for the rest. Pick out the really, cogent ones. Give them the answer. They'll never make an application because a lot of it is just fishing. So that's part 18 in noise-induced hearing loss claims in a nutshell. Like I said, there's a big section in my handout which you'll see. Last area that I wanted to touch upon. I've only got about 5 minutes left. It's witness statements. Now, witness statements, I've seen over many years different witness statements, and it's the most important document. A lot of witness statements are very vague. I've had so many engineers come back and said, well, we can't do anything. We can't, on the basis of the witness statement, we just cannot decide one way or the other. And sometimes some people think that's good, but it isn't, because if the engineer is sitting on the fence, you're not going to get home. So, and the thing that baffles me is this: why have a witness statement which is vague, unless obviously the claimant just cannot give that evidence? Why not probe him? Because the more detailed the witness statement is, the more information the claimant gives, the more he nails his colours to the mat, the better it is, because it's 99% of the time it's unchallenged information. Nobody can negate it. So the claimant says this is what happened. There's no evidence to the contrary ever. So the engineer is then in a beautiful position to then provide a full and proper report. The claimant's actually protected in cross-examination. Now, when you do a witness statement, and a lot of times witness statements miss out things, the background of the claimant's working life, age, family circumstances, employment history. What is useful is a table highlighting when he was exposed to noise, when he wasn't, his employment over time, whether hearing protection was provided, and then when he was with defendants who exposed him to noise, the periods of those employments, the positions he worked in, the nature of the work, full description of the, especially the defendants you're claiming against, full description of the building, the layout, the number of people who worked there, different roles, the different types of machines, whether the machines were maintained, how noisy they were, how bad he felt, and how far they were from him, whether he had a temporary hearing threshold shift, whether he went home with buzzing in his ears, and really detailed in relation to certain machines. If they're going to be your main machines that the engineer is going to comment on, for example, grinders, impact guns, rivet guns, do a small section on each and ask the claimant for as much information as he can. That is crucial information that the claimant can provide. Anger times, again, the claimant can say, well, look, I was using this gun or this grinder for so many hours. Out of an 8-hour shift, I was actually cutting things for 2.5 hours because we were doing this, this, and this. And if he explains it, 99% of the time, the engineer's got no other information but that to go off. So the engineer's going to come back and say, well, that's what the claimant's saying, and that's accepted. Then there is breach. It's only in very rare cases where the engineer will come back and say, although the claimant is saying that I was exposed to 3 hours on the grinder or something, in my experience, that's too much. He wouldn't have been exposed to 3 hours. In the type of situation he says he's in, it would have been an hour at most. That you get occasionally. I had somebody working on an oil rig, and the engineer in the case was an expert on oil rigs, and so he came back with a lot of information. It was just the way that the cookie crumbled in that case, but the engineer said, I've got so much experience of working on oil rigs, etc., 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 and he said, this doesn't happen. What the claimant's saying, I've never witnessed, and I would expect this, this, and this. And so it became a credibility case, but that is only occasional. 99% of the time, the claimant has the final word on this if it's all in the witness statement. Things like clattering, banging, screeching, sparks flying, buzzing, talking, can't talk, impact, lunch, can hear it in the canteen. All these things are important. Machine recollection, general noise levels, complaints from neighbours near the factory, complaints from other employees, health and safety executive, JCBs, digger drivers, machines, shift times, breaks, overtime, buzzing in ears, temporary threshold shift, enforcement of hearing, quality of the hearing protection, health checks, audiograms, and etc. And then in relation to limitation, you know, when he started to notice his symptoms of hearing loss, when he first started to notice tinnitus, how the symptoms progressed, who were his witnesses. You know, if there's a complaint from wife, then wife can give evidence, say it was only 2 years ago that he started to hear this. It corroborates his evidence. And then TVs, etc. Now, I've got a long list here, but again, what I've done is to help you, rather than just throw it all at you, I've put it in a detailed handout. I've done a kind of bullet by bullet checklist of the types of things that we need in our statements, and over time it's grown and grown and grown, so it's quite comprehensive now, and it just has quite a lot of things there that those of you who've got experience, and don't get me wrong, the vast majority of statements we receive are good, but there's always room for improvement in everybody's work, and especially mine. So I've been improving this over time as I've gone along to different trials. Say, well, that could have been in the witness statement. That could, things like you know, the signing of the CFA, where did you have the screening test and all this. These were things that I actually added afterwards, after claimants were being cross-examined on it. So I've built this up over time, so it'd be quite useful to you. I've just noticed there's some errors of numbering, but you can ignore that. That's not going to cause too much difficulty. So yeah, the better the witness statement, the more the engineer has got and the more chances of success. It's 32 minutes past now. I'm going to quickly run through the case of Mackenzie, which is a recent one. Then I've got a few other cases that I've put at the back of the handout, which probably already been sent to you. You might have received it on your emails. The Court of Appeal has clarified the approach of fact-finding in noise-induced hearing loss claims in circumstances where a claimant has difficulty in proving claim because the defendants have failed to carry out noise service. And in this case, it went to the Court of Appeal, and the Court of Appeal said, well, look, the defendants failed to carry out noise service. It's their fault, and so the claimant's evidence needs to be taken on those points. So it's a very good case for claimants. You've then got Holloway, which dealt with de minimis argument, and Lord, I think it was Lord Freeman, or Judge Freeman, who said, look, you know, if the experts are saying that the need for hearing aids has been accelerated, how can you argue that there is no disability here? There must be both experts agree that the need for hearing aids has been accelerated. And then you have a few more cases at the end there that recently I've seen. And then my last slide, so I've put all those in the handout with a brief summary of what they show. And the last slide was this, that after working in heavy industry, an older man has serious hearing problems. He makes a claim for an IHL, wins, and has hearing aids fitted that allow him to hear 100%. He goes to his solicitors after a month and says to his solicitor, your hearing is perfect. Solicitor says, your hearing is perfect. Your family must be pleased. And he says, I haven't told them yet. I've been sitting out listening to their conversations, and I've changed my will 3 times since then. So it's not, there you go, positive there. So that's the end of today's seminar. It's flown by. We're now 35 past, but I'm happy to deal with any questions that anybody's got on any of that. If I pause there and